Hello, this is Attorney Brian Pendergraft with the Pendergraft Firm LLC. And today's question I'll be answering for my Ask Attorney P series is, can a landlord or tenant provide each other notice by email? That said, this is legal information. This is not legal advice. If you are seeking legal advice, you can contact an attorney in your jurisdiction. And that said, this is part of my Ask Attorney P series. So if you have any questions that you would like to consider for my Ask Attorney P series, you can click the link in the description to ask your question. So back to the question, can a landlord or tenant provide notice by email? For example, let's say a landlord or tenant doesn't want to renew a lease agreement. So they send a notice of non-renewal by email. Now, is that notice sufficient? And I think the best answer is it depends. And it depends on the contract, i.e. the lease agreement, and the laws of that jurisdiction. And as a general rule, landlords and tenants are required to provide notice as it is outlined in the contract, i.e. the lease agreement, so long as it doesn't conflict with local laws. So some leases say notices can only be sent by email, whereas some leases may require notices to be maybe on the opposite extremes and require notices to be sent by certified mail return receipt requested with a copy of the notice sent by first-class mail. So that said, I would say as a general rule, it's best to send a notice as prescribed exactly as it is, as it says how to do so in the lease. Otherwise, the notice may not be considered valid. Now, if the lease is silent on how notice should be delivered, then it's best to look towards, local laws. Unfortunately, I can't answer that for every jurisdiction, but in my jurisdiction, first-class mail would be sufficient. That said, people lie about receiving notices all the time. So even if I send notices by first-class mail, I'm going to send it with proof of tracking. But again, you need to make sure that you are familiar with your jurisdiction's laws. So your jurisdiction may require for notices from landlords to tenants to be affixed to the property or something like that in order for it to be, in order for that notice to be perceived as valid. In fact, if you recall what I said earlier, the notices, they must be sent by the terms of the contract unless it conflicts with local laws. So your contract may say notices can be sent by email, but your local law may say, hey, these notices must be sent by posting a notice to the door or affixing it to the premises or whatever. And that's the case, then you probably have to follow what the local law says. So again, this is why you need to be familiar with both your lease agreement and with your local laws. And when in doubt, you can contact a local landlord-tenant attorney or property manager to shed light on what you need to do. So that said, I can probably help you if you're in Maryland or in DC or something, but if your property is somewhere where I'm not licensed at, let's say, California or something, I wouldn't be able to tell you that. A local attorney would be able to help you with that, though, or property manager. That said, if you have any questions that you would like considered for the Ask Attorney P series, just let me know by clicking the link in got a link in the description where you can ask questions. Thanks for watching. Take care.